I do, Your Honor.
You swear the information is true and accurate to the best of your knowledge?
Yes, Your Honor.
You want to go ahead and sign that and bring it up? Which of these folks do you want to work with first, Mr. Colson?
Ms. Smith, Your Honor.
Melonie, if you don't mind, why don't you go down there and have a seat next to Mr. Archibald? Court has in front of it the criminal complaint. I'll acknowledge the signature of Mr. Colson at this time. All right, today is Monday, February the 13th, 2017. We're convened in the Bingham County Courts, and we'll first take up Bingham County case number CR 2017-573. This is in the matter of the state of Idaho versus Melonie Dawn Smith. Are you Melonie?
Yes.
Melonie's here with us in the courtroom. Melonie, I'm going to go over 4 things with you. So, first of all, I'm going to try to help you understand what you're charged with. Second of all, we'll talk to you about being represented by an attorney. And then third, we will go over the bond issue. And then number 4, we'll set your next court hearing. So that's probably all we'll go over here today. Now, you have with you here today Mr. Jim Archibald. Mr. Archibald, appreciate you being here to help us with this.
Thank you, Judge.
Have you had a chance to go over the criminal complaint with Melonie?
Yes.
Now, Melonie, you have a right to have us read every word of that to you here in the courtroom, or you can waive the reading if you would like. Mr. Archibald, does she want to have every word read to her, or do you want to waive the reading?
Your Honor, we reviewed it downstairs just half an hour ago. She understands what the allegations are against her.
Melonie, I'm going to go over this with you just kind of summarily, so if you've got it in front of you, let me just go over this with you. This criminal complaint has the prosecutor's name up at the top there, Mr. Cleve Colson. He's present in the courtroom, representing the state of Idaho. In the middle there, it's got your name, your date of birth, your address. Is that information correct?
Yes.
And then down below that, it says it's based on a sworn affidavit, and count 1 is murder in the first degree, a felony. It says that it's punishable by a minimum of 10 years and up to life in prison or death and or a $50,000 fine. So that's the possible penalty. Count 2 is destruction or altercation or concealment of evidence. That's a felony, and that's punishable by 5 years and or a $10,000 fine. Let me just go over the charging language with you here quickly. In count 1, the allegation is that the said defendant, Melonie Dawn Smith, in the county of Bingham, state of Idaho, on or about February the 9th, 2017, did unlawfully, willfully, deliberately, and with premeditation kill and murder David Lee Davis, a human being, by shooting David Lee Davis in the head with a firearm from which he died. So that's the murder charge against you. And count 2 says that the defendant, Melonie Dawn Smith, in the county of Bingham, state of Idaho, on or about February the 9th, 2017, did willfully destroy, alter, or conceal a dead body, parts of human remains, blood, clothing, or other property containing blood matter or bodily fluids, knowing that the objects, matter, or items was to be produced, used, or discovered as evidence in a felony investigation authorized by law, and with the intent to prevent it from being so produced, used, or discovered. So Melonie, that's basically what you're charged with, that murder in the first degree and destruction, altercation, or concealment of evidence. Now, on the attorney issue, you filled out a notification of rights form and you've marked the box that you'd like to apply for a court-appointed attorney. And on your financial statement, you don't indicate you have any assets. Don't you have any assets? Do you have Social Security or any income or anything? Nothing.
Nothing.
And you don't have any money anywhere right now?
Nothing.
Okay. I'll find that you're indigent, and we'll appoint Mr. Archibald to represent you. And I would point out to you that I think, Mr. Archibald, aren't you on the Supreme Court's list of those few lawyers in the state of Idaho qualified to handle first-degree murder cases?
Yes, Your Honor.
And that's why he's sitting here with you, Melonie, is because there aren't very many people in eastern Idaho that are on that list. But Mr. Archibald is, so we'll appoint him to represent you. And Mr. Archibald, there is the issue of having a second chair, and so if the state decides to pursue a first degree, we'll have to figure out that second chair issue. So we'll figure that out later. All right, so we've told you what you're charged with. Number two, we've talked to you about the attorney. The third thing is the bond issue. Mr. Colson, on behalf of the state, what is the state's position on bond?
Your Honor, the state's request for bond in this matter is for $1 million. It's based upon the nature and offense and circumstances of the offense, as well as her criminal history and history of failure to appear in her past. Her failure to appear history specifically, it appears, is mostly from Canyon County, based upon the records by pretrial services. Based upon that, the nature of the offense, obviously the court's aware that flight risk is a concern, and that's the concern that the court's addressing with regard to bail in this matter. Based upon the nature of the penalties attached in this case, Your Honor, up to life imprisonment and or death, the state feels that there's a high risk of flight based upon that. And additionally, she has that history of failure to appear in court in her past. Thank you, Your Honor.
Mr. Colson, let me ask you a question about this.
Yes, sir.
This is one of those cases where it's a murder case. You could be asking for no bond. Why are you not asking for no bond, and why are you asking for $1 million bond?
$1 million.
No bond.
Correct, Your Honor. We are asking for $1 million bond. As the court's aware, the court can elect to post a no bond or enter a no bond in this situation. The basis for our request at this point is based upon our criminal history as well as the nature and circumstances of the offense. We believe that $1 million bond would be appropriate in this matter. Ms. Smith has indicated to the court here today she does not have assets. She has indicated to the court here today that she would like a public defender, which was granted. I think based upon those circumstances, based upon the analysis of the case, I believe our bond request is appropriate based upon the circumstances of this case specifically, Your Honor.
Thank you. Mr. Archibald, is $1 million too high or too low in this case?
Your Honor, if it's 100,000 or $1 million, my client can't post it. Just for issues of the bond, I'd note that she lived at the time these allegations with her mother, Betty Duke, at 70 years old. My client is 48 years old. She's a widow. She had been receiving her husband's retirement. She had been living off that for the past year. She doesn't have any children in the area. She doesn't have a job other than taking care of her mother. I don't know all the facts of this case, so I'm not going to argue likelihood of the evidence. Likelihood of conviction is also a factor under bond. I also have not been provided her criminal history, so I don't know yet about failure to appear history as referenced by the prosecutor. So the lower amount, the better. Obviously, some amounts better than no bond. Once the state files a notice of intent to seek the death penalty, then someone is automatically no bond. But since the state hasn't done that yet, would ask that a bond be set.
Mr. Archibald, I usually ask the defendants at this point in the proceedings if there was anything that they want to say on the bond. That's always a little bit risky for they're gonna say something that will incriminate themselves. Would you prefer that I not ask Ms. Smith to address the bond issue?
I purposefully asked the bond questions downstairs when I met Ms. Smith half an hour ago, and that's why, because I didn't want her to have to feel obligated to answer questions.
I think that's probably wise. Okay. Well, the court has reviewed the probable cause in this case and finds that there is probable cause. And the court is considering Idaho Criminal Rule 46 and the factors listed therein. And the court will set the bond at $1 million at this time. And because of that, we now need to set our next court date within 14 days. That will be our preliminary hearing. Joey, when do you want to do that?
February 23rd.
February the 23rd. We'll go ahead and set it for that date, assuming you gentlemen can be ready by that date. If not, you can let us know. But we'll set the preliminary hearing for February the 23rd at 8:30 in the morning. Any comment on that?
No, Your Honor, not at this time. Well, Mr. Archibald and I will have to work together to determine if that date's going to work for the parties.
Yes, thank you.
Now, Mr. Colton, it looks like you filed a motion to seal the records in this case. Do you want to address that?
I did, Your Honor. I filed a motion to seal the record pursuant to Idaho Administrative Rule 32G and/or Rule 32I and 32I1, 2A, D, and E, and/or E. Specifically, our request, Your Honor, is with regard to search warrants, affidavits of probable cause with regard to the search warrants. Additionally, the probable cause affidavit submitted here for the charging today. I don't have an objection, or I'm not motioning the court to seal the criminal complaint itself if the media is to make a public records request with regard to the complaint. The basis for the motion, Your Honor, is contained within the written motion for it, but I will cover it briefly. Specifically, there are facts contained within those affidavits and other court documents that may threaten or endanger the life and safety of specific individuals. In addition to that, there is a concern at this point with the right to a fair trial. We've indicated as part of the motion. So the motion is made across the entirety of that rule, which explains the specificity of what's required in these motions and is needed for sealing the file at this point. And I think that this case meets that, Your Honor. There is obviously high interest in this case, is evident at this point. And in order to preserve the record at this time, I would ask that the motion be sealed until this court determines it appropriate not to be sealed anymore. So at this point, that is the state's motion. Does the court have any questions of the state with regard to it?
I don't. Thank you.
Thank you, Your Honor.
Mr. Archibald, do you have any comment on the state's motion to seal the file at this point?
Your Honor, not having the probable cause affidavit myself, not having the police reports, it's hard for me to comment upon the sensitive nature of the investigation, so I'll leave that up to the court.
Thank you. All right, the court's going to grant the motion, and the court will sign the order at this time, and so we'll seal the file other than the criminal complaint. So we will honor a request for the criminal complaint, but beyond that, we'll seal the file for the time being. I suspect as the case develops, maybe that ruling of the court will change. But the court has signed the order to seal the record pursuant to the administrative rules. All right, Mr. Colson, anything else you want to do in Melonie Smith's case today?
Nothing further from the state, Your Honor. Thank you.
Mr. Archibald, anything else in Melonie's case today?
No, thank you.
All right, we'll be adjourned. Thank you. We could wait a minute.